for delivery of judgment. Item 1, WBC 8513/19, Aleha Khatun versus the Union of India.
In the aforesaid facts and circumstances, the impugn opinion dated 8/6/2015, passed by the FT third Darong in Mongolda in FT case number 293912 is hereby set aside. The matter is remanded back to the learned tribunal for fresh adjudication in accordance with law after giving opportunity to the petitioner to reduce our evidence. Proceedings shall appear before the learned tribunal on or 29/9/2026 to receive further orders till completion of the fresh adjudication. Petitioner shall not be subject to any course of action. Send back the this here, petition stands.
Item 2, for delivery of order. IA Civil 2482/26.
Yes. This delay conference petition is dismissed.
Right, please, my lord. So subject to item number 8, my lord. I have from
Date is 2021. Please wait. We have to see the record and then pass on. Consider when the matter is called.
then, my lord, I may not be available because I will
Ask somebody to be here because we are not adjourning any 2021 matters without looking at the record.
All
We have
right.
515 cases pending and for 2021. And the things are taken.
All right.
May I please have a motion? Similar prayer motion, item number 9, my lord. I will come in question time, my lord. Similar prayer motion, Master friend, regarding the item number 9, my lord.
9, just wait.
Yes,
Please
my
wait till
lord.
when the matter is called.
Yes, I'll come in question time. Yes.
For motion, item 11, WBC 8816/19.
The fine to just see the records because he has taken a plea that there is there are two opinions. First opinion is at page 17 of the petition, and is projecting that his father was declared to be a Indian by opinion at page 66. Just to the records, if it is there, then the one is page 66, one is at page 17. You have a copy of the writ petition? You take this.
Item 1 for admission.
May I please, Lord, sir? Here, impugned judgment is case 179. On limited ground, I filed this appeal, madam. The initially they filed one repetition, madam. There is an order, madam, and they challenge the termination order, madam. But the first repetition was, madam, there is no, it was termination was or not set aside, madam. To direct them to consider the case in a revision board, madam, about CRPF, madam. So, my lord, the second, my lord, only it was rejected, my lord. The board rejected their prayer for this employment, my lord. And my lord, they filed repression against the rejection of the board, my lord. On medical ground, my lord, the repressioner, my lord, he was appointed as a constable, my lord, CRPF, my lord. And immediately in 2000.
There's a recent judgment of the Supreme Court of people getting injured during training.
Yes, madam.
They can't be kicked out. They can't be removed from service. That is what we have read.
Yes, madam.
Where is that judgment?
I have not right now. I have not, madam.
Because we read it in the live law. We just have a temporary memory of.
Only thing is, my lord, in this case, my lord, the person concerned, my lord, he has not completed the basic training, my lord. So, my lord, and he is not fit for day-to-day work also, my lord. So only this award, my lord, the prayer before the learned single judge, my lord, the ex gratia lump sum amount, my lord. Lordship made down the page 171, my lord.
Appeal, we don't find anything to counter the finding at paragraph 17.
Paragraph
17, there is a reference to that SO 4 of the 2011.
Paragraph 17 of my judgment.
Of the judgment. Because if the object of this notification is to rehabilitate.
Yes, my lord.
Then there is no material on record that you have complied with that.
This our case before learned single judge was, my lord. This moment a person, my lord, they complete the basic training and oath, my lord, as far as Rule 9 of the CRP rules and rules, my lord. He is then only then they complete the servant under the CRP organization, my lord. His service will be counted, my lord. Here, my lord, is during the course of the training period, my lord, he was training start 2011, my lord, 2015 up to 2015, my lord, he was under the treatment of the CRPF, my lord. And 2015, my lord, this because he could not complete the training, basic training, and he was terminated, my lord. This was the case, my lord. So whether this without the completion of the oath, my lord, he may be counted as a the temporary his service may be counted as a temporary service under this law, my lord. This my lord, rule 9 is concerned, my lord. Rule 9 of CRP Central Reserve Police Act, my lord, the rules, my lord, 1955, my lord. The attestation of oath or affirmation. The oath or affirmation set out the in Appendix C, to which the rule shall be administered by this with this ceremony by the commandant, to all officers and rank and file. The officer, administrator, or oath or affirmation shall attest that he has done so by signing an understand paper which shall be attached to the service rule of this member of the force of the concerned matter. So here, my lord, he has not completed this the oath, my lord. So that in that particular, my lord, case, my lord, where his he will be treated from this his service will get a temporary service, my lord, under this act, my lord. That was our case, my lord.
CRPF Act.
My lord, in 2000, my lord, 2011, my lord, 3rd June, my lord, his training was started, my lord. And immediately, my lord, in December 2011, my lord, he injured, my lord. And continuously up to 2014 itself, my lord, he was under treatment under the CRPF hospital, my lord. And 2015, my lord, he was terminated, my lord. And thereafter, the writ petition, my lord, challenging a termination order, my lord. But termination order is not set aside, my lord. And the honorable court directed to place his case before the reevaluation board, my lord. The board, my lord, not considered because he not completed basic training and he is not fit for the day-to-day work under this CRPF, my lord. And then thereafter they filed this present petition, my lord. Here, my lord, the discussion, he is the employee of the CRPF, my lord. His the service is called a temporary service. And this so far there's the instruction is concerned, my lord, he may be accepted in other work, my lord. And set aside the termination order also, my lord.
Which provision you were referring to when you said that they have to take oath of oath?
My lord, the rule 9, my lord, rule 9, my lord, in my book is page 17, my lord. Attestation of oath and or affirmation.
Which provision is there for appointment is section rule 4 and 5.
Yes, my lord.
Rule 4 says in all cases for a composition of force.
Rule for composition of force, my lord.
5 is composition.
5 is composition of force, my lord. In company, my lord, there is this much, my lord, constable, my lord.
Where is his appointment order?
Appointment orders, my lord. It is, my lord, page. Appointment, my lord, appointment was page 36, my lord.
See?
36. My lord, date of appointment, my lord, date of appointment, my lord, next 36, my lord, was my lord, July, my lord, first
July 2014,
2010. This is issued, my lord,
2010. And he was discharged when?
2015, my lord.
Okay, he got injured when?
Injured, this starts from my lord, December 2011, my lord.
December
He
2011.
he joined in training, my lord, start, my lord, 3rd June 2011, my lord. And December, my lord, 22nd December
Training
2011,
on?
my lord.
Training on which date?
Training starts, my lord, 3rd June, my lord, 2011, my lord.
1st June.
Yes, my lord. And thereafter, my lord, he, my lord,
2011.
11. And thereafter, my lord, on 22nd December, my lord, he hospitalized, my lord.
Then this order of the learned single judge does not warrant any interference.
My lord.
Then the order of the learned single judge does not warrant any interference. Then you have not been able to make out a case.
Only another thing is, my lord, I want to show here, my lord. So far, the board is concerned, my lord. This board, my lord, this is, my lord, page 68, my lord. Page 68, my lord. Regulation of force personnel, my lord. Lord, we got it. The department has 3 categories of disabled person. A, those who are disabled due to injuries sustained in action against the terrorist, / anti-social element, / insurgent and / Naxalists while maintaining law and order, / internal security, / undergoing training or any other bona fide duty. So, my lord, here, my lord, these are the ground, my lord, considering, whether the underground training and basic training is As per my lord, single was both are
You see,
same.
once you appoint him, he becomes a member of the force by operation of section 5.
That is true, but unless my lord he taken oath, my lord, he is not complete. My
No,
lord.
you see, in your act and rules, there is no prescription about the date on which he has to be given the oath. You see, if he is appointed as a constable and you don't give him oath for 1 year, then what
I
happens?
understand, but my moment, my lord, this as per medical board, my lord, this my lord pays 100 and
Medical board will not override the provisions of the act and rules.
Yeah.
That is your internal arrangement.
But as per my lord, the medical board, my lord, press 171, my lord, he is not able to do any activity like PT
But that
parade.
is okay, you discharge him, but that has to be in accordance with law. Your rule says that you can discharge him within 3 months of the date of appointment. You did not exercise that option then because he was fit. He got injured during training. And as per the medical reports, he perhaps broke his kneecap.
Both, my
Or knee
lord,
joint.
not only single, both, my lord.
It's okay, whatever be. But in the process, he got a degenerative disease of the of that medical, what is the term? Medical meniscus. That is a small bone which moves the knee. That got misaligned. Patella and the patellar ligament and quadriceps tendons. Are there, but lateral meniscus tear occurred. Whether he is fit or not, the act does not say that you can discharge him on medical grounds. That is good enough. If you have a policy that he cannot be rehabilitated, that's good, but otherwise we'll have to discharge him in accordance with law.
So this limited my ground is appeal, my lord. So whether my lord, this initially this the termination was not set aside in the earlier education, my lord. Subsequently, my lord, there is no prayer for termination of the same said order. Now, my lord, this honorable court, my lord, without the prayer of the setting aside the termination order, my lord, this order was passed, my lord. So as per there is this, I place one judgment of the honorable apex court, my lord, relating to other matter, my lord. Here, my lord, this I've already lifted in the grounds also, my lord. Page 7, my lord.
The writ petition.
My lord.
Which page is the writ petition?
Writ petition starts, my lord. It starts, my lord, page, my lord, 20, my lord, from 20. Prayer is page 33, my lord.
Yes.
My lord, so far this judgment is concerned, my lord, in the, here, my lord, what happened, my lord, the cabinet memorandum was silenced, my lord. Memorandum of silence, my lord, subsequent regulation of this service of the appellant.
You're reading where?
It is page 7, my lord. I mark is, my lord, is undisputedly, my lord. Page 7, my lord. Honestly, appellant have silenced only the cabinet memorandum dated 16/6/2000 in the writ petition before the High Court, while cabinet decision 13/10/2000 was taken on the basis of the said and subsequent regulation the service of the appellant issued by the state government had remained unsilenced. The cabinet took the decision so and so in exercise the power of the rules so and so, which was subsequently notified the government on so and so as on time measure to regularize the service. It appears that the appellant were not serious in regard to challenge the regulations of service of the private residence, but were only interested to pursuing their own claim for appointment of against the vacancy. In this circumstance, the appellant cannot maintain any claim whatsoever in the circumstances against which the appellant and private respondent completely different footing. So here, my lord, this subsequent or this order, this in his determination was order was not silent in a subsequent requisition, my lord. So, but honorable court on the learned single judge, my lord, interfered the termination order itself also, my lord. So my humble submission, my lord, is unless there is a prayer, my lord, and it was also indicated in the other court also, my lord.
Yes.
To pull down of the appellant member, the memo of appeal. So other grounds are selected. And this ground regarding the prayer not mentioned, but the Lanet court has Lanet civil judge has my paragraph number 40. That answer that my lord. Page number 195. And the medical is not focused the prayer portion is not notice taking the petition there as a prayer for any other order the and paragraph number 40, page 195. So it is correct that the order of discharge of the petitioner from the court is not challenged in the present execution. However, in the considered opinion of this court, then cannot be a ground for dismissal of the execution. More particularly, glaring error committed by the respondent in discharging the petitioner from service without following due process of law and only the opinion of rehabilitation board. The fact also remains that termination of service of the petitioner is not preceded by any of the procedures prescribed under the rules. So, my lord, the single is, my lord, very much within jurisdiction, my lord, under 226, because there is a prayer, the lordship found the repetition that any other order can down of the court may be improper for the entry of justice, page number 34. So 226 is prayer is not required because the entire process your lordship will find that the other ground that he was not a member or he has not taken the vote. The line that has elaborated discussed all these matters. May I read paragraph number 11 onwards, three paragraph of the judgment, 196 from the and single judge has elaborately discussed all the matters points raised by the current council in the before the single judge matter. And may I read paragraph number 11 186. Paragraph number 11, my lord, in the case in hand, page number 182. It is admitted position that offer of appointment was issued to the petitioner by the commander, 10th Lieutenant and swearing him to report confluence of. Clause 1 day of the offer of appointment declares that the appointment on temporary capacity of to continue. The offer of appointment also carries the definite state of pay. The respondent employee in the affidavit has also stated that the petitioner enlisted as the group center was allotted 174 CRPF and after enlistment, the petitioner was dispatched from group center to training for basic training. Thus, from the aforesaid factual position, it is clear and admitted that the petitioner was appointed to the force and was also enlisted enrolled as a member of the force. He was also allotted a particular battalion in the aforesaid background fact as well as terms of the definition of member of force in terms of Rule 16. Rule 16, he is the constable, my lord, and all the employees are member as per Rule 6. Rule 16 of the rules, this court has no hesitation to hold that the petitioner was a member of the force at the relevant point of time. The magistrate has emphasized that non-completion of basic training of the petitioner is content that if for want of training, the petitioner cannot be treated as a member of the force. Now let this court discuss an argument. Training is dealt with chapter 5 of Rule 55, which consists of 1 Rule 26. That rule prescribes the nature of training, which is required to be given, and the same is enumerated 26B. Rule 26C empowers the commander to depute any member of the force to undergo a course of training, and Rule 20C prescribes that the period of training is to be treated as duty for a person of his post duty, FR 961. Being under it falls, government servants to be treated as on duty during a course of instruction or training in India. Thus, from this angle, also the training can be imparted to a member of the force, and such period of training is treated as on duty. Therefore, from the context, the petitioner at the relevant point of time during training was a member of the force. Though in absence of such training, he may not be eligible to be engaged in activity duty defined under 2A of the Act of 1949. Therefore, the same cannot be a ground for rejection of the re-education under SO 4 of 11. It is not even a ground of rejection of the benefit of SO 4 of 11. In fact, the Lanet has therefore in alternatively submitted that matter may be demanded by the authority. But the prayer of the council was before the single judge was to refer the matter. In the Lanet single judge has accordingly referred the matter for a fresh consideration. Then how this appeal is maintainable? As per his prayer, my lord, the matter is remanded back, my lord, page number, for a moment I go to the page number, my lord, 195, my lord. 195, my lord, 42, paragraph number 42, my lord. What is the, my lord, decision of the granted single judge? Married, my lord, thus from the discussion made and reasons reported herein above, following conclusion can be made are issued. Though the petitioner has a temporary post, he is to be treated as a member of the post in the given practice present case. He will be entitled to benefits required to be granted to a temporary employee who gets enlisted during the course of employment. The Department of Immigration Board failed to exercise its power in terms of SO 4 of 11 and rejected the claim on the grounds which are not sustainable under the aforesaid SO 4. Therefore, such issue is struck down. The discharge of the petitioner from service is also not in terms of the rules of 1965 and therefore claim is sustainable. Accordingly, the matter is delegated to the employer to take a fresh decision in terms of the determination made herein above, and thereafter the respondent employer shall pass a speaking order deciding the benefit that can be granted to the petitioner on becoming eligible for the injury sustained during the training. So, my lord, it is not a direction to reinstate him in service. A single judge has only relegated the matter to the rehabilitation board to pass an order as part of the matter SO 4 of 11, as part of discussion of that. So, Madam, may I continue from 17, madam? That the learned council has not very much had a quantity that I have come, madam. Diagram number 17, last part, madam. The learned council has not been even able to lay any material, including any executive instructions whereby the injury sustained during basic training is excluded from the benefit of S4 of 11 or that until and unless the training is completed, a person cannot be treated as a member of the force. And S4 of 11 is not issued only to for these circumstances alone. And my learned senior counsel has mentioned that your lordship spoken to notice that it is a one condition is injury sustained during training. Your lordship has noticed it. So he has admittedly he has sustained the injury during training, and for which the SO4 is applicable, my lord. Now, in paragraph 18, the rehabilitation board, while rejecting the claim of the petitioner, had opined that the petitioner would not be able to take any strenuous work, and the CRPF is highly active and mobile force, where he has to take a lot of physical work even to lead a normal camp life. Thus, the claim of the petitioner has been rejected on two counts. Firstly, he has not completed the basic training, and secondly, he will not be able to perform the strenuous physical activities CRPF. Now, let the court deal with the ground of rejection. The object of S4 11 is for rehabilitation of disabled force personnel. Disabled persons under standing order code of 11 are those who have become disabled due to injury sustained during employment, which includes injury sustained while during training. Such disability has been categorized under different heads. It is an admitted position, my lord, that the petitioner suffered injury during training during course of the employment. The criteria for referring an injured person to the Department of Rehabilitation Court is enumerated in paragraph 4 of SO 4 of 11. It prescribes that when the medical officer is of the opinion that there are no signs indicators of improvement and that the individual is not fit for normal active duty, the case of the individual should be referred to the Department of Rehabilitation Board of the unit concerned. Thus, the fitness is relatable to active duty. Active duty is defined under section 2A of the Act as duty to restore and preserve order in any local area in the event of disturbance thereof. The conditions to grant rehabilitation are of twofold. There are no signs of indication of improvement from the injury, and the person is not fit for formal active duty. In terms of section paragraph 6 of S411, SO411, rehabilitation board ascertain whether the injured can be rehabilitated within the court by assigning the jobs mentioned in paragraph 7 and 8 of SO4. If the member of the court is not fit for any kind of duty, the rehabilitation committee can recommend the injured to invalidate out. In the case at hand, paragraph 7 SO411 is relevant since it is relatable to individuals who are below the rank of ASI, constable, and the other paragraph 7 of the OM prescribes certain jobs, such as injured who is enumerated below. So a person who is not able to do the active duty matter, for which is that runner, telephone operator, room welfare, salesperson, canteen, RTO railway station, office job, mess constable, any other specified jobs are there. Therefore, SO411 is as discussed herein above. The determination of the board regarding the incapacity of the petitioner to do tenant work itself is contrary to SO411 in as much as under the scheme rehabilitation is prescribed for those persons who are not fit for normal active duty and is able to perform the duty enumerated under paragraph 7 of SO4. Some of the jobs earmarked for rehabilitation in the paragraph do not even need any strenuous work. Such factual determination as regards ability capacity for a specific job is within the domain of the employer rehabilitation committee. However, while arriving at such decision, the consideration is to be made in terms of the prescription of SO 11. Thus, the consideration that is to be made is whether the person can perform the duties as enumerated in paragraph 7. The fact remains that SO 11 also describes situations where no engagement can be made due to total incapacity. Paragraph 9 of SO 11 prescribes that person with 10 years of service to his credit, if so, is unfit to perform any kind of duty, shall be recommended for boarding out of the force. Subpara B of para 9 SO 4 further prescribes that the person having 10 years of qualification service at the time of invalidation will be entitled to disability pension, subject to the condition that their disability is applicable to work duty. Those persons who do not have 10 years of qualifying service are required to be dead in force. So he only 4 years of his duty, there is less than 10. So he is to be retained in the force for up to 10 years to make them eligible for invalidation pension, subject to their being within the place in terms of the evidence standing order. So below 10 years, there is no provision of relieving the injured constable. Then when a person is not even able to perform the duties under paragraph 7 SO 411 and therefore cannot be rehabilitated, the authority is to determine the status of fitness of the injured and to proceed accordingly for declaring injured permanently incapacitated by the medical evaluation board. However, none of the aforesaid exercise has been carried out in the case of the petitioner, and his case was erroneously rejected. Such benefit was also denied on the ground that the petitioner has not completed basic training of the injury and will not be able to complete his basic training in future. Therefore, in the considered opinion of this court, the vital aspect of the rehabilitation has been ignored, and emphasis is being given to the strenuous nature of the duty allotted to a constable PG. Therefore, this court has no hesitation to hold that decision of rehabilitation board is not in consonance with the requirement of SO 4, whether it is contrary to object of such rehabilitation. It is not in dispute that the disability pension as envisaged under Rule 1339 is also applicable to member of the court. This court mentioning had a Rule 52 of 1955, the fact that all members of the court on duty or on duty in the military court shall be entitled to own injury family pension for gratuities as laid down civil service regulation 1939. In fact, as discussed here above, SO 4 deals with disability pension in terms of the aforesaid rules. Rule 3A of the Rules 39 provides that disablement is to be accepted as due to government service, subject to the condition that it is certified that such disablement is due to own injury attributed to the government. Rule 1939 is applicable at all central government employees, whether their appointment is permanent and temporary on the scale of 6 fees per day. Rule 3A of the Rules deals with disablement and death. It provides that such disablement pension can be awarded in terms of 2039 when the injury found is attributed to the government service or existed during the government service and has been given aggravated. Rule 8 of the bill is a percentage of disability rules prescribed and disablement of government service concerned. The rule 3 as such person is required to be awarded disability pension so and so. Rule 13 prescribed here the procedure and such pension shall be as prescribed. That is ordinary basis. That from the aforesaid it is clear that there is no such prescription of qualifying service when a person is invalidated due to disablement considered for benefit under 39. In terms of the Rule 1939, is the employer who is to have a satisfaction on the basis of medical record examination of the employee carried out by the employer, that employee has become disabled to perform his duties and such disability is attributed to service condition and he is being discharged from the service and therefore he is able for disability pension. As discussed here above, in the case in hand, it is an admitted position that petitioner is a member of the court in terms of the Rules 1955 and definition under section 2D of the Act 1949, and he was on duty during his training. The injury sustained during duty has to be deemed to be attributed to the government duty. Therefore, from this point of view, petitioner shall be entitled to the benefit of 1939. Procedure of termination of temporary employee under central government is dealt under 1965. Admittedly, initially the service of the petitioner was terminated in terms of Rule 5(1) of 1965. So, my lord,
Assistant, all throughout the country,
My lord,
the same view has been taken for almost all the courts. That once he is appointed, he is member of the courts. And therefore, he'll be entitled to whatever has been done by the learned single judge, same thing has been done. Rule 38 of the CC's pension rules, as well as section 47 of the Act. I want to get
47. CRPF. Free transport on enlistment. On enrollment, member of the force is entitled to free railway pass from the railway station nearest to his home or place of enrollment. Disability accumulated is exempted from women enforcement.
We are not inclined to interfere. This is the correct application of the law by the Reverend Single Judge.
Only I want,
There's no material before us to show that the appointment of the petitioner was subject to the oath.
that is not there, but the rule says, my lord, oath is required, my lord. Another thing is, my lord, this,
Okay, you can
Well,
you can give him oath even after 10 years.
and another thing is, my lord, in petition also in paragraph 4 stated, my lord, he is in ad hoc training center, my lord. And we also they explain the ad hoc, he is in ad hoc training center in page 114, my lord. Petitioner remained the influence.
You see, but you have not been able to show that the training is not an in-service training.
My lord,
You see, when we appoint judicial officers,
training is
when we appoint judicial officers, they are appointed on probation, subject to condition that they will undergo the training.
yes, my lord.
Now we give them training. For that, they are not given any post.
Here is no oath is required, my lord. In other service, oath is not required, my lord. In judicial service, oath.
Every service oath is
My
required.
lord, in constitutional post, it is oath is required, but in normal service, my lord, oath is not required.
That is your problem that you have not given it to him.
And my lord, there is difference between under training. There's two types. One is, my lord, the basic training, my lord, when is he recruited, my lord. This
You see, you could have dismissed
18
him within
months or
3
like.
years. 3 months, you have not done so. He was there for several years. You can't say that having been the member of the force for so many years because of oath.
And he has
He would
given
not-
all, my lord, medical treatment up to 2015 itself, my lord. And after that, from the department, my lord, medical treatment, my lord. Question, my lord, normal question, my lord, this type of never happened, my
You
lord.
see, when I joined office, I had no problem. But while I have a sitting job, I have this slip disc and all these problems. They have started. So what to do? This comes free with this chair, and I am suffering for it.
Yes, my lord.
Then
Workload, my lord, is there. Been an advocate of sometime, my lord.
no workload. My own load is giving me the problem.
That is true, my lord. So this is the my basic, my lord, my prayer manner and grounds, my lord. Lordship will decide accordingly, my lord, because
We are not. Heard. Mr. S.K. Mehdi Lanet, CGC for the appellant. And Mr. M.J. Kadir Lanet, counsel for the respondent. Next, by filing this intra-court appeal,
only I want to point out one thing, my lord. My learned friend says, my lord, is remand back, my lord. But the paragraph 42, my lord, this, my lord, the petitioner services temporary force, he is to be treated as a member of the force, my lord. So, my lord, now he is, as per this order, my lord, he is a member, there's not remanded, my lord. Only to consider whether we will engage in some other work. That is the page 195.
appellants have essayed the impugn judgment and order dated 25/7/2024, passed by the Honorable Judge in WPC 4606/2020. So stop. The effect of the order, the effect of the said judgment and order Just say, comma, thereby allowing the repetition. Next paragraph. In brief, comma, the case of the appellants is that the respondent, comma, who was the writ petitioner, was selected for the post of constable within bracket general duty bracket post in the Central Reserve Police Force within bracket CRPF for brevity bracket before, while the appointment letter dated 10/7/2010, comma, issued by the commandant, comma, 147 Battalion BN, comma, CRPF. Accordingly, on 11/1/2011, comma, the respondent had joined his duty at Dayapur, DAYAPUR, comma, Silchar. And upon joining, comma, he was sent to the CRPF training center, comma, Nimuch, NEEMUCH, comma, Madhya Pradesh. However, while undergoing training, comma, he suffered injuries in both his knees. Accordingly, comma, he was admitted to Composite Hospital, comma, CRPF at Nimuch on 22/12/2011. Thereafter, he was referred to Composite Hospital, comma, CRPF, comma, New Delhi for further treatment. And thereafter to Safdarjung Hospital, comma, New Delhi. He was discharged from Safdarjung Hospital on 23/1/2012. He was referred to different hospitals from time to time. And ultimately, he was discharged on 9/2/2012. On 26/3/2012, the respondent was issued a medical certificate of fitness to resume his duty by the authorized medical attendant, Composite Hospital, CRPF, New Delhi, and he resumed his duties at, however, after 2 months, he again complained of pain in his left knee, and he was referred to the Composite Hospital, New Delhi, on 8/6/2012, from where he was referred to Safdarjung Hospital on 23/6/2012. He was, it was as the petitioner had to be hospitalized on several occasions, it would suffice to mention that even after issuance of fitness certificate to the petitioner on 15/9/2012 at the Composite Hospital, New Delhi, the petitioner was hospitalized on several occasions from 1/2/2013 due to (30/8/2014). Subsequently, the respondent was referred to a medical board on 10/3/2015. The medical board opined that the petitioner was not, that the respondent was not fit to undergo strenuous and rigorous physical training. So accordingly, by an order dated 27/4/2015, issued by the commandant, Group Center, CRPF, Bilaspur, within brackets capital CG, bracket close. Service of the petitioner was, the respondent was terminated as per the provisions of sub-rule within bracket 1 of Rule 5 of the Central Civil Services within bracket temporary service rules, 1965. So, subsequently, by another order dated 27/4, another order dated 10/6/2015, the earlier termination order dated 27/4/2015 was amended so as to make it a order under Rule 6 of the CCS within bracket temporary services bracket close rules, 1965. Agreed by such termination order, the respondent had preferred an appeal before the Secretary to the Government of India, Ministry of Home Affairs, New Delhi, as per sub-rule 2 within bracket A, Rule 5 of the CCS within bracket temporary services bracket close rules, 1965, which were disposed of by observing that as per Rule 6 of the 1965 rules, the petitioner was terminated on medical ground and there was no provision for appeal against such order. Stop. The respondent then opposed this court by filing a writ petition which was registered as WPC 4498 of 2015. The said writ petition was disposed of by order dated 25/2/2020 with a direction to consider the case of the petitioner in terms of the standing order number 04/2011 as amended, within bracket, hereinafter referred to as SO-4/2011. full stop. Accordingly, the petitioner had appeared before the Departmental Rehabilitation Board by an order dated 19/6/2020. And he reported before the Departmental Rehabilitation Board on 7/7/2020. Full stop. However, the Departmental Rehabilitation Board by an order dated 14/9/2020 rejected the case of the petitioner for rehabilitation under the rehabilitation scheme. Stop. The claim of the petitioner was rejected on the ground that A, that the respondent had not completed his basic training and will not be able to complete his basic training in future. And he would not be able to take any strenuous work in CRPF, which is a highly active and mobile force where he has to take a lot of physical training to lead a normal life in the camp. Semicolon, then B within bracket. The respondent himself agreed to his physical condition and requested for some monetary compensation, which was not permissible under the rules. Semicolon, and within bracket C, after examination of the physical and mental ability, aptitude, job requirements, etc., he was not found physically fit to be rehabilitated for any subsidiary role of constable within bracket general duty, bracket close, under the given rules and regulations. Full stop. Next, the appellants had contested the petition and the learned CGC appearing for the appellants had submitted that the respondent had not challenged the termination order, and in absence of such challenge, he cannot be granted the benefit, as claimed, and reliance was based on the case of Mukul Saikia and others versus State of Assam and others, AR 2009 SC 747. It was also contended that the matter be remanded back to the government for relief in terms of Government Office Memorandum dated 4/8/2017, issued by the Ministry of Home Affairs, for cases with disability and payment of ex gratia lump sum compensation. It was also contended that the respondent was not entitled to any benefit under the rehabilitation scheme, as he was not a member of the force at the time of the accident, and he was only a trainee, and his training was not complete. semicolon, comma, and within bracket C. It was also contended that neither the training of the petitioner was complete, nor both was taken by the petitioner in terms of respondent, rule
Rule
9 of the CRPF rules, 1945. And accordingly, the petitioner was not, the respondent was not entitled to the benefit of rehabilitation, as the said scheme is meant for the member of the force and not for the trainees. Next one. The learned single judge, placing reliance on section 18 of the CRPF Act, 1949, section 18, which is that the 1949 Act. And accordingly, it was held that the petitioner was a member of the force. Being offered appointment by the commandant on 10/7/2010. And accordingly, it was held that the petitioner was appointed on temporary capacity with a definite pay scale. So accordingly, it was further held that the respondent was enlisted as constable within bracket general diary, a general duty bracket post on 11/1/2011 at the group center of CRPF future, and was allotted to 174 Battalion CRPF. And after his enlistment as constable within bracket general duty bracket post, he was dispatched from the group center of CRPF future to recruit training college within bracket RBC-1 bracket post, CRPF, on 13/5/2011 for basic training. Resultantly, it was held that the petitioner was appointed to the force and was allotted a particular battalion. And by referring the plea of non-completion of basic training, took note of the opinion of the rehabilitation board while rejecting the claim of the respondent that he would not be able to take any strenuous work in the CRPF. Next one. The learned single judge considered the object of SO-4/2011 and arrived at the conclusion that the same is for rehabilitation of disabled force personnel. And was further held that the condition to grant rehabilitation are twofold, i.e., there are no signs or indications of improvement from the injury, and secondly, that the person is not fit for normal active duty. It was also held that the exercises as was required to be performed, to be carried out under the SO-4 of the 2011 was not carried out in the case of the petitioner. Sorry, now responded, and his case was erroneously rejected. And it was held that the benefits were also denied to the respondent for not being able to complete the basic training for the injury suffered. Next one. Learned single judge found the petitioner to be entitled to disability pension What is the 1939 Act?
My lord,
What is 1939 Act?
yes, my lord, there is another act, my lord, is the correct, my lord, file runs.
Pension civil services extraordinary pension.
Central Civil Services within bracket extraordinary pension bracket was used from 1959. And moreover, it was held that the SO-4 of 2011 also dealt with the disability pension in terms of the said 1939 rules and the 1972 rules. And accordingly, on finding that the petitioner was a member of the courts in terms of the 1955 rules, the petitioner was found entitled to benefit under the 1939 rules. to stop. Moreover, one, referring to the procedure of termination of a temporary employee under the 1965 rules, it was held that the condition precedent for terminating temporaries, the persons under temporary service on account of physical unfitness without notice was to declare him physically unfit for continuance in service. On after discussing the methods available on record, it was held that the rehabilitation board had not opined for invalidation of the petition, and nor did they opine that the petitioner was permanently incapacitated for work, public service. Accordingly, it was held that the termination order of the petitioner from service was not supported either by any authority who had been competent to declare him as permanently incapacitated for service had his appointment been permanent, nor any exercise to that effect was carried out in the case, resulting in violation of the right of the respondent, not only under the scheme of 1949 Act and 1955 rules, but also under Article 21 of the Constitution of India. Next, the Honorable Civil Judge had held that under the present facts of the case, or the ratio of the case of Mukul Saikia within bracket Supra cannot be made applicable in the present case. The decision and the reasons of the court, as summarized in paragraph 42 of the judgment and order is reproduced below. Paragraph 42. Page 195-196. Next. The learned CGC has reiterated the contention which was made before the learned single judge, as referred above. Specifically submitting that as the termination order was not under challenge and there was no there in the petition, the ratio laid down by the Supreme Court of India in the case of Mukul Saikia within bracket Supra would apply. And the petitioner would not be entitled to any relief. It is reiterated that without taking oath, the appointment of the petitioner was not did not confer to him any right to be reinstated in service or to apply SO-4/2011. Next one. The learned counsel for the respondent has made his submissions in support of the impugned order, judgment and order. Next. It is not in dispute that the respondent had not challenged the his termination order. But the and apart from paying for setting aside the order dated 14/9/2020, by which the recommendation which of which the authorities had rejected the recommendation of rejected as per recommendation of District Rehabilitation Board dated 30/7/2020. For rehabilitation and for reinstatement in service. Next. It is not in dispute that the petitioner could not, that the respondent could not complete his basic training after initial appointment. And it is during the training period that he had suffered injuries which caused prolonged treatment to be suffered by the petitioner, sorry, respondent, and was not administered the oath because his training was not completed. In the present case in hand, it would be appropriate to refer to the provisions of section 47 of the Persons with Disabilities within bracket Equal Opportunities, Protection of Rights and Full Participation bracket was Act, 1995. which amongst others, under subsection 1 thereof, provides that no establishment shall dispense with, or reduce in rank, an employee who acquires a disability during his service.
Yeah, Disability Act is not applicable, man. Disability Act is not applicable, man. Where,
For CRPF,
yes, sir, we are exempted, we have, yes, madam. No, affidavit, my lord, we have, my lord, the next, my lord, this. My lord, page, my lord, 130, my lord, this notification, my lord. And 31, my lord. In exercise of power conferred provisions, section 47 of Disability Act, April 7, the central government here requires all categories of post of combatant personnel exempted. Central Reserve Force, BSF, for instance.
That will not be there. Disabilities Act. In the present case in hand, comma, the petitioner had been appointed to the post of constable in the general duty in the CRPF, where appointment letter dated 10/7/2010 was issued by the commandant of 147 Battalion of CRPF. Therefore, merely because the authorities did not give oath to the petitioner on his basic training not completed, not successfully completed. Yet, the petitioner was not declared to be physically unfit for continuous in service. Where the authority competent to do so. Who's talking about? Accordingly, a mere fact that the petitioner did not complete his training and is not given oath did not come in the way of the court to issue appropriate direction in terms of the SO-4 of the 2011. Accordingly, the court does not find any infirmity in the decision of the learned single judge that the termination of the respondent from service was not supported either by any authority who had been competent to declare him as permanently incapacitated for service. So accordingly, notwithstanding that there's no challenge by the petitioner, respondent, against the termination order, but as the respondent had raised in the petition for reinstating in service, the learned measures had not committed any illegality or perversity, not applying the ratio of the case of Mukul Saikia within the in the case of the respondent. This would come in the way of the learned single judge to set aside the order of termination. Next part. In the present case in hand, the learned single judge had recorded the plea of the learned CGC to be sent to the sent back to the employer for determining the entitlement of if any of the petitioner for compensation under the Government Office Memorandum dated 4/8/2017 issued by the Government of India or Ministry of Home Affairs. Yes. This precisely said here of the learned CEC which was allowed in the petition by relegating the matter to the employer to take a fresh decision in terms of determination made in the order and to pass a speaking order deciding the benefit that can be granted to the respondent on becoming disabled for injuries sustained during training. Next. In view of the state contention, state order is paragraph 4 within the capital Roman 3 of the impugned order, the judgment order. The court is of the considered opinion that the impugned order dated past by some is not required, is not required in the opinion. Accordingly, the petition, the intercourt appeal fails, the late appeal is dismissed. Next. Delete is granted by the runs just to the respondent. Be provided, and the exercise shall be carried out by the respondent party within the extended period of 6 weeks from the date of service of a certified copy of the order to the this will go to whom? Certified copy before whom?
My lord, respondent 2, my lord.
He's now not in 174 battalion.
My lord, the commandant is respondent 3, my lord, 174. My lord, initial appointment, my lord, Silsar, my lord, is respondent 5, my lord.
But will be the competent authority now. This order of rejection, this termination is passed by whom?
Termination is passed by Bilaspur, my lord, the respondent number 3, my lord. Page 61, my lord.
On the tree.
My lord, 2 and 3, my lord, the copy was forwarded to my lord, IGP, Chhattisgarh sector, CRPF, my lord. Raipur, respondent 2, my lord. In space 61 reflected, my lord. All that's one, all that's one.
Yes, Mr. Kadir, certificate copy to whom?
We submitted to all the respondents earlier. Earlier we submitted to all the respondents.
All the respondents, okay. So all the respondents by speed for this AD.
Here respondent number 5 will be 147. It will be not 172.
47.
There is some typing error. We'll correct.
Certificate copy of the order for the respondent.
Termination to Bilaspur. One, 7, Single judgment, learned single judgment appeal, my lord.
Item 11, time being item 11.
Yes.
In the healthcare in the healthcare doctor. There is a specific thing that his father was declared as a Indian citizen lordship and lordship. I could find a link between him and his father lordship. So lordship, I leave it to your lordship.
There is a link.
Yes, sir.
But the difficulty is that if the petitioner is not there,
Yes, bro.
it becomes very difficult to serve the order and then to have it implemented.
But again, notice has to be issued to him.
Hmm?
Otherwise,
Again,
if your lordship,
notice has to be
notice has to be issued against. Then it's a.
Okay. Just make a note of it. We'll take it up on next week. The Nana phase on second call for the petitioner. So how all the respondents are represented. For range of justice, the matter stands adjourned today. List again on date after 2 weeks.
May I please, Your Honor? The petitioner hearing my lord has been declared foreigner. Impugn order is at page 62. Petitioner exhibited the 1966 voter list in the name of his grandfather. In 1970 voter list in the name of his grandfather. In 1989 voter list in the name of petitioner's father. And subsequently petitioner's name. And so far linkage is concerned, my lord, school certificate was exhibited, there is exhibit 1. The exhibit 2, 3, 4 was discarded. That is at page 65, the reason is given. Discard. That is Page 65. 9. May I read it? Proceeding had produced evidence, also exhibited some documents to substantiate her statement, and accordingly analyzed those documents along with the evidence on record to determine the nationality status of the proceeding, and R as Annexure B is the print copy of legacy debt code of the year 1966, whereby recorded the name of the grandfather of the proceeding, namely Faraz Sheikh, son of Sialu Sheikh of village 122, so and so. But the same has not been proved by adducing cousin and reliable evidence, and in such circumstances, production of documents carries no evidentiary value and is not admissible in evidence, and therefore this same is not acted upon. So for Exhibit 2, Exhibit 3, and Exhibit 4 are the certified copies of digitally signed voter lists of the 1966, 1970, and 1989, respectively, whereby recorded the name of the grandparents, namely Faraz Sheikh, Kasurani Bibi, and also recorded the name of her father, namely Muqsed Ali Sheikh, son of Faraz Sheikh. In relations column at village so and so, under so and so, my lord, and when compared with the print copy of the voter list of the year 1993, that is the Annexure B, found the name of the father of the proceeding is Mosbar Ali Sheikh, son of Farasuddin, in serial number so and so, so and so, so and so. That one Annexure B that was not exhibited, my 234. That is of discarded. In respect of grandfather, that is Exhibit 2. In the written statement, my lord, is 14. Exhibit 2, 3, and 4. So written statement, my lord. My bit DW2. What's up? Page 40 I have. 46 is the cross.
Everything good in your evidence is taken away by this cross-examination. When you cross-examine, you say that your parents casted vote, but you cannot say which year. You casted vote, but you cannot say which year.
That is,
It's not a fact that I was born and brought up at Devatar. So therefore, this demolishes your case. It is also not a fact that my father was born and brought up at Devatar, Param Ganga.
no, it's my lord.
It is not a fact that the name of my father is not so and so. So therefore, this part of the cross-examination, that is, discloses you everywhere.
It should have been, it is a fact, should be. That is the illiterate mind, my lord.
The lawyers are there, they don't read.
My lord, that is correct.
They get signed.
That is my lord. No, it is not a.
Item 3. Item 3.
Page 30 is the emblem. Here, only case is, my lord, the evidence of the father and two documents. Otherwise, as well as 22 document has been exhibited. Twenty-three document has been exhibited. My lord. My lord. We will also kindly see page 38. In the new judgment. And we will also kindly see page 39. The exhibited has been as 22 documents. Now we will also kindly see the original father of the petitioners belongs to state of Bihar. The original petitioner, they are permanent resident of the village Purihar Toli, Jahapaha, UNPS Purihar, subdivision Sitamarai, district Sitamar, then Muzaffarpur, in the state of Bihar. Then the father of the petitioner has moved in various places while he was 16 years of age. And lastly, he came to Assam and started to settle in the district of Tinsukia. And he also married one Marjina Begum. And the petitioner, born in the year of 1982 at village Bahadur Sareli Moza, Tipling, subdivision Tinsukia, in the district of Tinsukia. And when he got majority, and he married one Marjina Begum of that village, and he is to permanently settle in that village, in his in-laws' house. Then when the notice was issued, and the petitioner examined two witnesses, including his father, and exhibited some documents. Page 13 is a written statement. Page 13 is a written statement. You will automatically see page paragraph 4, page 13. That's 1. This village has been taken. And the paragraph 5, he specifically stated the procedure of filing this written statement before this terminal without any knowledge of the ground on which he is alleged to be a foreigner, and as is hereby, he will leave up this tribunal to amend the filed additional written statement. So, ground of allegations are not furnished to the petitioner along with the notice. And name of his father is Hanif Sheikh. Grandfather is Hanif Sheikh. And grandmother is Zaimun Nasa. And great grandfather is Olier. And the father name of the Usman Milo. And he stated the family details in paragraph 8, 9. Of the written statement Milo. Under the matter was decided to expertise, and he was taken into custody, and thereafter it was recalled, and the petitioner contested the case. Then also can see page 44 of the opinion. Here, the exhibit 13, 14, 16, 19, and 21, Lanet member relied on and held that those are not readable documents, which are in Urdu language, and someone is Bhojpuri language. And although chance has been given to the petitioner to get translation, but same has not been done. So learned member could not consider those documents. And thereafter, page 44. Page 44, my lord. Exhibit 12, onward, my lord. According to the London Council, appearing for the proceeding is a certified copy of the sale deed. However, as Exhibit 12 is not at all in readable condition, as such, the contents thereof could not be understood, thus not analyzed in true manner. More so, the DW2 also failed to disclose anything more in his evidence as regards Exhibit 12. The documents exhibit thus remains unproved. Exhibit 13, 14, 16, 19, and 21, 20 also could not be relied upon, as most of the relevant passages of the aforesaid documents mentioned in Urdu language, which could not understood, thus not relied upon. Moreover, some are also, same are also not proved in accordance with the provisions of law. And that apart, the learned counsel, namely Mr. S. Rasqua, appearing for the proceeding, had been requested many times to translate the Urdu version of the said land records, either in Assamese or English, but he has neglected to do so, leaving nothing to believe the contents of the said documents. These documents therefore are no help in support of the citizen of Gauhati. Exhibit 17, my lord, is a translated copy of some documents, but it is not clear from Exhibit 7 as to which document has got translated by Exhibit 7, and as such, this also render no help. Exhibit 18 is a copy of the Khotian, but it is not indicated anywhere in Exhibit 18 as to for which period the said Khotian has been prepared and published. In absence of any such pleadings in respect of evidence of Schedule 1 and 2, it therefore cannot be presumed that Exhibit 18 is prior to the cutoff date of 1971. That apart, it is also not pleaded anywhere in the respective evidence as to on what basis the name of Khotian holders had been recorded in Exhibit 18 and oblique or what was the source of in getting the Khotian holders name entered in Exhibit 18. In absence of any such specific statement, in this behalf, merely claiming advantage of the documents will not suffice. Moreover, the Khotian holders named in Exhibit 18 are not properly identified by the Schedule 1 and 2. Exhibit 8 also not seems to have any reliability. Similarly, Exhibit 21, which is a rightly Khatian, stand in someone's name who are not at all related in any manner with the parental parents, family, Schedules 1 and Schedule 2, and therefore the contents of those could not be found convincing one up the satisfactory level does of no use. These are the findings, my lord, and if you look at Kalisi page 61 of that Khotian, plus 62 of that Khotian, my lord. You will also kindly see 1858 serial number Khotian. Sheikh Suleiman, Sheikh Farman, Sheikh Usman. Sheikh Usman is the father of the petitioner. And it is a document of year of 1967. Page 63, last part, my lord. 7 July 1967. Exhibit number 1. That two will be.
Single bench item.
May I please, your Lordship, I am praying for adjournment of item number 3, Lordship. Your Counsel, Mr. Acer, sir, will address the matter, but some personal difficulty is not well, Lordship.
You want an adjournment?
Yes, Lordship.
Item 3.
Item 3, on the prayer made by the council for the petition, matters is adjourned today. List after.
List after.
Definitely. Okay.
Item 1.
May it please, Your Lordship. Your Lordship, this is paragraph number 5 of the last order.
Yes.
The extension has been given.
Division bench item 1 for orders. PL Sumoto 1/18 with PL 60/9.
Malad, I have received the up-to-date information, Malad.
Oh, this is a good progress.
Look, the cabinet has approved now. And Malad,
Progress.
I'm told, I have spoken to the editions yesterday. He said that already the memorandum from the cabinet has come. So they're in the process of drafting the notification. It will go to the, for publication, Malad, shortly, Malad.
I'm just thinking about, before the draft is actually sent to the act, can we have a look at it?
Beyond that.
Before the, that conference, Malad,
Department is saying, because we should protest now, we cannot get any change of policy. It will be there. That is the subject to challenge also.
Okay, then
before this.
we have done the matter for some time. Let it come. How much time?
I'm informed that before the conference, state level conference, possibly on 5th of September,
Yes,
it will come before that.
5th of
September.
September,
September,
before that.
it will come
Oh,
before that.
that is wonderful.
Lots.
We appreciate the effort.
And Lordship has directed the secretary of the legislative department to appear personally to apprise the position. My secretary is there now.
Okay,
They-
okay, that's
they have-
okay. Once
they
it
have
is
done
done.
their part. They have
Okay,
done-
we record your presence. Kindly give, you have your name?
I have.
Okay,
Lots.
Madam Mehbooba,
Unmute, you have to unmute. Both.
Good afternoon.
yes, we take, take notice of your presence.
Yes,
We
sir.
record your presence. Your name is?
My name is Mehbooba Begum. I'm
Okay.
Joint Secretary to Government of Assam Legislative Department. Presently, I'm Secretary in charge as my secretary is on leave. So
Okay.
today I'm here in behalf of my secretary.
Okay. Um, It is, record our presence, Head Mr. N. Chaudhary, Council, Learned. Council for the, petitioner in PIL 60 of 2019 also heard Mr. H.K. Das, Mr.
N.K. Sharma.
N.K. Sharma, learned counsel, appearing on behalf of Mr. H.K. Das, senior counsel and standing counsel for this court in PIL within bracket Suomoto 1 of 2019. Also heard Mr. R.K.D. Chaudhary, learned DSGI, Mr. D. Nath, learned senior government advocate, along with Mr. N. Kalital and government advocate. And you are there, and Mrs. R.H. Chaudhary, learned standing counsel for the Assam State Legal Services Authority in PIL Suomoto 2 of 2023. Next para. Pursuant to order dated 21/7/2026, the learned senior government advocate has produced a copy of written instructions dated 21/8/2026 by the Deputy Secretary to the Government of Assam, Women and Child Development Department, stating that the Legislative Department has already vetted both the draft Assam State Child Protection Policy, 2026, and the draft Juvenile Justice within bracket Care and Protection of Children, bracket rules, 2026. First off, it has been stated that after vetting, the matters were already placed before the Honorable Cabinet on 18/8/2026 for its consideration, and on receipt of the minutes of the Cabinet, appropriate steps will be taken for notification of the same. Next paragraph. The learned senior government advocate has also submitted that the attempt is being made to notify the same as early as possible. Next paragraph. The court records appreciation towards the Women and Child Development Department for the effort taken so far. Full stop. Next paragraph. The court hopes and trusts that the said policy and the rules would be notified at the earliest. Next paragraph. Does this matter on?
For in October, when will start the other issues?
We have a lot of meetings now. Service तारीख में दीजिए तेरह तारीख ओके 14 का मोशन दे है ओके 14th of October.
Now be ready for the other issues.
We will press the other
Once it
issues.
is resolved, then what are the other issues? So like those issues, then we'll.
Specifically, the concern is with regard to that issues of education. That And Mr. Chaudhary, you were flagging one more issue on that day. Huh, yes, yes, that is more important. So just remind us of that on the next date.
One chart for I have placed that logic record. Will logic.
No, in fact, on the other issues, we have not applied our mind today.
True.
So, just on the next date, the issue of the children homes, please renew that on the next date.
The children home.
In fact, that chart and the audit report already placed before your lordship. That will be helpful for that.
We will try to provide a concise chart of what all other issues are necessary to be undertaken.
Whoever is lacking.
And you can also suggest ways and means how to have it monitored. Because we have the department doing it, but some NGOs or someone who can do this.
Who could actively take up the matter?
Only the inspection part, because we are not trying to create a third authority. Just they will have the inspection done and make the reporting, the sort of thing to assist the court.
Think over it.
Just think over it.
For effective monitoring. Once those areas plagued are resolved, then the situation continues and improves. That part is more important. Continuous monitoring.
Just
We will try.
thank you. Your presence would not be required on the next date. Whenever is required, we'll inform.